justice denied for how long? That means our system is not working.
Now another drama is unfolding here, right in front of our eyes. I think South Africa is a banana country. It's a Mickey Mouse country, whereby criminals can walk free.
The leading authority says the second docket in the SENZO MEYIWA murder trial has no merit. That document, which is the internal opinion of a junior state advocate, implicates the 7 people who were with Meyiwa when he was murdered, including Kelly Khumalo.
Fellow members of the bench and Court of Public Opinion, welcome back. I'm your host, Mrs. Independent, aka I'm not a lawyer. So we're talking about the elephant in the room, docket 375, and listening to all this, I am thinking if the NPA decision was not to charge, those reasons should have been made in writing to SAPS and the complainant of the case, of the docket, of that docket 375, and it should have been recorded as such so that there is no confusion that is confusing our confusion as we stand right now. But let's take a listen further to this.
Twist in court today when a second docket was revealed. And that docket is calling for all those present at the house in which Meyiwa was killed, the visitors, to be charged. The docket names Kelly Khumalo, her sister Zandi Khumalo, and her mother Gladness Khumalo as suspects in the crime. The defense for accused number 5 wants to know why they were not previously made aware of the second docket. ENCA reporter Slinde.
Clarity from both DPPs regarding Exhibit D, wherein they decided to charge other people and later stage decided to charge these people. I cannot be able to proceed. Public prosecution South Gauteng had decided that the following people, my lord, be charged, which is number 1, Longwe Twala, number 2, Kelly Khumalo, number 3, Gladness Khumalo, number 4, Zandi Khumalo, number 5, Tumelo Madlala, number 6, Mthokozi Sitwala, number 7, accused 7, it's Maggie Piri, my lord. The accused, whose name I've just read into the record, my lord, who acted as perpetrators or accomplice or accessory after the fact, unlawfully and intentionally killed SENZO MEYIWA, an other person, by shooting him.
It was opened in 2019 by the investigating officer of the same docket, who initially they were together. They were a team of 4 before that docket of 375 was opened. So all of them, the Makubu and the Geninda, they were on 636. It was after a crucial statement was stolen out of 636 by one of them. Then that's when this second docket came in, because in the 375 there is an allegation of the defeat in the end of justice against one of the police officers. Hence we've got the 2 dockets today.
The NPA maintains the matter is sub judice.
The National Director has requested a report given the interest that has been generated by what transpired yesterday in court. Upon reflecting on that report, we'll make a determination of how to deal with the matter moving forward.
Yazi ukuthi kusini kunamaphoyisa afika lapha nezikhulu ezithile oqale kwabanje imeeting ukuze kungashiwo iqiniso lokuthi uSenzo wadubula ngephutha kade xabana noZandi ngoba iyona into esusa umsindo kade xabana noZandi kwasuka umsindo lapho ngalokho ngeke ngiye kuma details kodwa ke siyazi ukuthi kwase kufika izikhulu ezithile kwathiwa no lento ayigoqwe kuthiwa no kungena igebengu endlini zazobamba inkunzi wagcina uSenzo edubula kanjalo futhi amanga lawo siyazi futhi nokuthi kwa isini yaklinwa isini unanomama nje sengizomusha ngoba sebemshilo bengathanda ukusho uMampiri siyazi kudala ukuthi wafika lapha endlini wazi waklina kahle kade esho nawo usayitsheni Msiya ethi akabonanga uSenzo wawelapha lapha ngoba la wakhona kwakunegazi kodwa baklina.
Kelly Khumalo's lawyer says her client still wants her day in court.
She's been anticipating, and she asked me again yesterday, why was she not first called as a witness to be able to provide evidence, because she was present as an eyewitness at the scene, sorry. So for herself, she's anticipating her day in court to provide the evidence that needs to then show value in terms of corroboration with whatever has been presented by Sergeant Musia.
I don't know why this case bafuna ukuyenza u-X ongasolveki, honestly, because at the end of the day there is a common person, there is a common denominator, and that person is allegedly Kelly Khumalo. Okay, so the IO on 363 said she is the mastermind, and Utifo also said she is the mastermind. Not the mastermind per se, but the one who pulled the trigger. So now when you look at 375, it says all those who were in the house, including Kelly, should be charged. So hence I'm saying she is the common denominator. I don't know why did Gininda and Baloi wanted this to be matrix or Exonga Solveg, but let's continue listening to the legal analyst.
Yes, I mean, Kathy, I'm as confused as you are, and probably the statement issued by the NPA has just created even more confusion. You know, my understanding was that there were two dockets. One had been investigated and no decision had been taken to prosecute in that docket or not to prosecute. So in a way, the NPA always left the door open that they could revisit that docket and make a decision whether to prosecute or not to prosecute. But we must bear in mind that there are five accused before a court now charged with the murder of SENZO. And one of the charges involved is the assault on two people who were in the house. I think it's Ms. Khumalo and her mother. Now, quite significant is that you would have to bring in either of the two to at least give evidence about the assault, and obviously probably to give evidence about the murder itself, because the assault would have occurred in the context of the murder. Now the NPA is coming back, it's saying, look, in their statement at least, we're waiting to see whether the credibility of any of the people in the house is not going to be challenged to make a decision. That means firstly that they intend to call some of the people or the people who were in the house to give evidence. But secondly, it seems like they are double parked now, because if there is at least a prima facie basis to believe that any of the people in the house was involved, those people should be appearing in court with the other five accused.
So,
untidiness in this whole matter is when you have a situation where people probably, and I don't know whether the second docket, in the light of this statement, makes a suggestion that the people in the house were involved in the murder, or whether it is still a question of the opinion of the investigating officer, probably out of frustration, because I suppose they would have, having interviewed whoever was in the house, maybe they formed a view that they are either not being told the whole story, or that the people are covering up themselves and they were involved. But you must remember that these five accused who are appearing in court, two of them, I think, are said to have made confessions. So it does not follow that they will not be convicted. I think the story that Advocate Kherinel has raised about the mastermind, comes back, and it will probably haunt us until either this trial is complete or the second docket is also activated, if it is ever going to be activated.
do you think it's a case of having a plan B?
Members of the bench, remember to like, subscribe, and share the video. And what I would like to say to you is forget about 375, because from what I heard from the legal analyst, those people are not going to incriminate themselves for docket 375. And another legal analyst is saying exactly that. Take a listen.
That no way, we will wait until this matter is decided to decide what we're going to do with the other matter. How are you going to do that? Because pictures and any other investigation that happened in that docket directly relates to this one. So how are you going to use accused persons in docket 375 to be state witnesses in docket, is it 636? I don't understand how that's going to work. It really does confuse me.
So you're saying you're critical of the MPA here. The MPA is saying that it'll wait for this trial to finish first, dealing with the one docket, and then it'll deal with the second docket. So presumably it will wait to see if the 5 are sentenced or found guilty. Is there a legal rationality behind that?
I don't see it. I don't see the legal rationality behind it. For example, this current witness that is before the court that is yet to finish his evidence because he's still under cross-examination, is the NPA saying that his evidence is different in terms of forensic and all of that from the forensic evidence that's collected in 375? What are they trying to say there? Is the photographer that took the pictures at the scene for docket 636 different from the photographer that took pictures under docket 375? How are you going to tear apart this case and make it independent of either one, 636 versus 375? I don't see how it's going to happen. But unfortunately, the accused persons have pleaded not guilty, I beg your pardon. The trial has started its part heard. So we can't exactly go de novo right now. So the matter has to proceed. This is why Advocate Mushololo is trying to cover her client and say that once this matter is done, in the event that her client is found guilty, now she has grounds for appeal to say, based on this irregularity, the SCA now has grounds to hear my appeal because I had it officially recorded in terms of Section 317, unlike it being a discussion that the way it was had for a very long time with advocates before, but without it really being on record.
All right, so it